Oh, hello. Yes, you're
Hey,
live.
Nick, what's happening, man? Hey, how you doing, my buddy?
Hey,
Look, see, I got a
I'm doing
smile back.
great.
See the smile there? It's
Look
like,
at that. Oh, look at that. Yeah,
yeah, I can't say
and
I'm getting back a little bit. I mean, I don't know. I'm putting my toe in, but I wanted to come on your show specifically because you've been so kind and so supportive and so everything. I mean, you are just one of the most amazing people, and
oh,
I don't even know what I do to deserve the respect. I mean, I guess I don't deserve anything, but you've been very kind. I want to thank you and come on and say that at least because sort of I got about a half hour or so here.
mm,
We got errands and we got things I got to do and places to be on this Saturday,
well, well,
including.
well, Miss Gosney, you are, in my opinion, one of the good ones. And yeah, so when you got that character assassination by the Miami Herald and others, yeah, I got your back.
I appreciate that. Well, but I've done a lot of reflecting, and I'm still not completely in through my head about how that happened. It's definitely changed my perspective a little bit. But one of the
Yeah.
things is that first of all, people really came through. A lot of my friends stuck by me.
Mm.
A lot of people did not. A lot of people just judged a book by its cover, right?
Yeah.
And that's all they did. And they didn't. I mean, it was that article was so false. It was the anti-truth. It was
Mm.
exactly the opposite. I mean, you know me, and you know what I stand for. It's
Mm.
exactly opposite of what I am, which is
Yeah.
it wasn't just a bad. It was
Mm.
intentionally opposite of what the
Mm.
actual truth was. So,
Yeah.
so that was tough. But the thing is that and then of course what it really happened was the mob came after me, right? The anonymous who also didn't read. And I one of the things that I don't want to dwell on the negative. The thing that I kind of realize is that everybody comes and I push my books, buy my books and stuff.
Mm.
I don't necessarily. I mean, I want you to buy the book, but the most important thing is that people read.
Yeah.
That they read, because this is the thing. I know who bought what. There was only 3 people in Miami that bought my book. So they obviously didn't read it. They read
Yeah.
this stupid article and they made these judgments and they took major positive action to go and get me based
Mm.
on and without even having read the book. You know,
Yeah.
it's like this surface level thing. And this is why what you're doing on this Young Thug Regal trial is so important because
Mm.
you are seeing the corruption and the problems and the destruction of the system. And you're seeing it firsthand and you're letting your viewers see it. And
Mm.
that's what I'm kind of share, like why I'm so anti-death penalty. Could you imagine giving Fannie Willis, you know, the death penalty, the power of life and death over its citizenry?
Yeah.
You want to
Yeah.
do that?
Yeah. For me, it's unfathomable. But here's the thing: there are a good bunch of people in this world who are incapable of doing better. So they have to bring others down to appear better, to give the illusion. And this is the surface level virtue signaling that we see on so many levels in society from people who simply can't do better without pushing other people down for the illusion to look good.
Which is isn't it that's very much the communist appeal.
Yeah.
You know, the appeal of communism is jealousy and hatred. And that its foundation, that's what it is. And that's the thing. They can't stand it's like you've got to be in the I'm in this, and I think it's a lot. And I know that we disagree on faith, but to me, it's a loss of faith because they look at if you don't have faith, and I believe we are all broken we have original sin, meaning humanity is broken by its very nature. The world is broken. It's fallen. It's a fallen world. It's a sinful world, right? Christianity offers a solution to that problem. And that solution is redemption through Christ, right? Now, if you don't have that exit plan, then you know that we're all fallen people. But it's now we're broken. And so somebody tries to crawl out and not be broken. They have no solution, so they just want to drag you down and say you should be broken too. It's like it's a faith problem essentially. But I mean, I'd like your perspective because I know you're not as big on the faith stuff as me. But how do you perceive that placing your faith in false idols idea?
I mean, we have way back when, we have something called the Jante law, which the basics of it, don't you think you're better than me? And and that is the core of communism, that no, everybody is on the level plane, but at the same time, no, you're not better than me. So everybody tries to push each other down. No, you are worse. No, you are worse. And if somebody goes out and say, yeah, I did this, don't you think you're better than me? So that is the basics. So in my opinion, it has less to do with faith and more to the human nature of destruction.
I understand, but how do you solve that problem without faith? I mean, I don't think you can, but I know that you don't have as deep a faith as mine. But yet we agree on many things, right?
Mm.
So, do you see that there is a solution to that without faith?
This
That's tough question, isn't it?
Yeah, it's a tough question, but I believe we need to listen to, for instance, with the what we call the elderman society, or elder women for that matter, that people with experience and what I affectionately call as don't have enough F's to give, who doesn't care about the judgment part, but just people, if you do good, do good.
Well, let me ask you a question. And I think you believe in the truth, right? You believe that there's truth and falsity.
Yeah.
Don't you think that is a leap of faith?
I believe, in my opinion, it is more analytical and in the probabilities, and then thinking 4 or 5 steps ahead. What are the consequences of my actions? If I do something that feels good now, but the consequences might be bad, should I still do it? And in my opinion, what I try to do is, sometimes I do things people might not see. Why did he do that? Well, because probably it is because I thought a few steps ahead. Okay, I will reference the which hopefully you don't know much about, the Kayla B situation that arose here. Why did I act like a yenta or a gossip lady about that? And that is, I care about the 12 remaining in jail, who has been in jail for 2.5 years, who are waiting for this trial to end. People's decisions in this trial and the surroundings will affect these guys in some way, shape, or form. And when you do something weird, strange, as allegedly, not 100% confirmed yet, even though I believe I do have everything I need, if an attorney who represents a witness in a trial ends up marrying one of the defendants, how can that affect the rest of the defendants?
Well, and again, I haven't followed. You have done an amazing job to follow this trial the way you have. But I mean, as an outsider to the trial, but an insider to the system, I can say that this trial, there's no way any outcome of this trial can be seen as justice.
No.
There's no way it's something you've got. Why don't we just try everybody? Sorry. Why don't we just try everybody in one big trial? We'll just have like every defendant in the entire country set one big trial and determine cosmic justice for everybody. And we'll just let the trial run for 20 years. I mean, well, there's got to be. It's like, well, that's absurd. Okay, you've got 20-some defendants or all these people, and you've got a year-long trial. That is absurd. No way should that be allowed to happen. They should break it up into individual pieces and have little 2-week trials on each defendant on the major charges, dump all the stupid little charges, try them on the big charges and do them one at a time and have little short trials controlled. When you've got a trial that's half a year long and we're not even near close, there's no way the jurors are not going to base their decision on any evidence. It's going to be lost in the muck. And you've punished them by the system. You've punished the defense attorneys. You've punished the jurors, and the outcome of the trial can't be relied on. That's aside from all the cheating that they've done.
Yeah, but we have this misconception that it is equal terms in court. It's far from equal terms in court. You have the government with your money, taxpayers' money, endless. If they want 10 million more, they will get 10 million more from somewhere. And against is people who, now Mr. Williams, lucky for him, he has lots of money. Mr. Stilwell, lucky for him, he has some money. The rest of them don't have money. And Jeff from Legal Vices has a good example. Everybody remembers the O.J. Simpson trial. Oh, he spent $6 million on his defense. Of course he was going to beat them. But nobody talks about the $10 million the state brought into that trial. So even with $6 million from O.J. Simpson poured into this, he was still $4 million short of what the state brought in.
Well, the state, it's basically you have there's sort of, it's an interesting balance in American system. It's kind of odd because the state just has a office full of prosecutors, right? And they can assign 10 people to doing this all day, every day for the rest, for the full year. Now that does take away from attention on other cases, but it's just, as a matter of trial management, just as a matter of basic lawyering, this prosecutor has failed because they have not put reasonable limits. This is not a trial. This is not a fair trial, just by its design and nature. We saw this in the Murdaugh case too, but this is a lot worse because the Murdaugh case, there was 3 weeks of irrelevant testimony about theft of accounts and stuff. But I mean, I think he really did that stuff, right? He pled guilty and he was guilty of sin in that. It was just swamping the trial and the evidence. This is what, half a year of confusion and all that. And they're there, and they're just on top of that. They've got all of these other problems with this trial should go away. It should be a mistrial and it should be with prejudice. And I don't know whether or not the defendants did it or not. I mean, I'm saying even if they did do what they're accused of, it should be a mistrial and should be with prejudice because of the screw ups. Because how else is the prosecutor ever going to have any kind of discipline going forward? If they win by attrition, think about that. They can beat you down and put you in prison for life because they have attrited, because they have all these resources just as mere power, and we can pound on you until you surrender. Yeah.
And in this trial, it started with 28 defendants. During, I have construction workers downstairs. 9 took plea deals. Starting with 6 months after they were put in jail without bond, up until just before the trial started a year and a half later. And now they have additional people taking plea deals, 4 people in this trial. And for me, how is it fair that the state has the power by exhaustion?
Right, that's what I'm saying. Exactly. And they do have that power. They do have that
overcharging power. Putting them in jail without bond, in jails that are basically prison camps. I mean, the closest I have in comparisons are Korean War prison camps. Sorry for that.
No,
I do not have kidnapping victims in my basement. It is construction workers.
That's right. No, it's really, this trial is a disaster. And I mean, that prosecutor needs to be removed. They need to, she is an embarrassment. The Georgia Supreme Court, they need to be stepping in. I don't know. They need to take up some of these interlocutory appeals and just grant the mistrial and let the chips fall where they may. It's an embarrassment to the country. It's an embarrassment to the people of Georgia and Atlanta. This is Atlanta, right?
Yeah.
And it's a lack of discipline. It's the prosecutorial function being hijacked and broken. For what reason? Assume this guy is guilty. He did it. All right. Prove it efficiently.
Yeah.
Is that too much to ask? Prove it efficiently. Don't, if the state wins by attrition, and there's no way the jury can make a rational decision based on this type of absurd trial, right? They're not producing justice. They're not producing a just outcome. That is a mockery of what our system is supposed to be. And it's frightening, because now you've got judges here who are on if you have a judge and a prosecutor who both, there's really, the defendants don't have any chance. Now, hopefully you have a judge. This judge seems like she's better, but she's reluctant. She won't take the hard decision and grant the mistrial. I've noticed that this is something that's endemic, and so maybe one of the things that I've realized in my experience recently is that courage is not something that political leaders can manage. Now, because when I was growing up as a young prosecutor, I had a guy named John Tanner. Well, you know John Tanner. He prosecuted Eileen Wuornos, right? He was my guy who hired me into the state. And that guy had moral courage and moral conviction. And he would say to me, is it the right thing to do? And he would stand up for what's right, to hell or high water. Like, he would say, this is right, and I'm gonna fight for that. He would stand up against people that would say something. No, I don't, I'm a politician, but I'm also going to stand up for what's right. And he would do that. What do you think about John Tanner, my mentor, one of my buddies?
When I covered the Eileen Wuornos trial, the Florida-based female serial killer, from that trial was, it was a long trial by that time and standard. It was, I believe it was a 3-month long trial. And with 56 or 57 actual trial days. But that was including sentencing phase. So they were, in comparison, they were quite efficient. But what caught me was the judge.
Bucky Blunt.
Yeah. Oh, nobody dared to screw with that judge. He sat there leaning back with his military haircut, almost looked asleep. And if somebody tried the slightest thing, eyes up, leaning a bit forward, and it was like everything stopped in the courtroom. And somebody screwed up. And the cleanliness of the prosecution.
There was a respect for the law and the system. Yeah. And the judge respected the law. The parties respected the law. They respected fair play. Now, he was an aggressive trial attorney. He was not a pushover, and he was an advocate. He was an alpha dog, right? But yet he also, there was something bigger than him, and that was the truth. He was a very strong Christian. Got in trouble. There's a lot of history behind Tanner I can tell you about, but he was the person that I came in as a prosecutor as, and he was the guy that hired me and that was tapping me to move up. And I will say his protege, or one of his chief assistants, was Steve Nelson. You don't know him, but he was he would always say, do the right thing. Do the right thing. And that was something like, I remember I'd bring up something tangential, like, well, this defendant, they've got this. And he's like, well, what's that have to do with the case? I remember he'd say that to me, and I'm like, oh, I don't know. Maybe nothing, right? He's like, well, I don't want to hear about it. Does it have to do? Is it relevant? Does it have anything to do with the case? And I don't want to hear it. And and he would really cut to the point. And see, that is like old school prosecution. That's the way that it should be done. This, whatever the hell they're doing in Atlanta, it's not the way it should be done.
Yeah, and I understand, because I had Max and Doug, who are defense attorneys. They have high praise for this, for Judge Whittaker, who just joined. Yes, of course, because in comparison, she is amazing. But I still have to say, I've been covering trials from all over the United States, and I do have my background in European law. It's not that good. She still is scared of the hard decisions. As you said, she has had a dozen opportunities to call for a mistrial with prejudice. She has in court, in open court, told the prosecution that it seems like you're making stuff up as you go along.
She should not pre-announce. Yeah, she should not pre-announce that this is a real problem with judging, and they should not pre-announce whether it's with or without prejudice. What you do is you grant the mistrial and let the chips fall where they may.
Yeah.
Because the right call, it is a mistrial. It is error. It is prejudicial error, harmful to the defense, and then argue about later whether it's with prejudice. But you just grant the mistrial because this thing is a mistrial. There's so many mistrials. I mean, when I paid attention, I've been in and out of this trial, and you've been sticking with it. There are so many grounds for reversal and mistrial. It should have been great for her to look behind the curtain and say, well, because of this consequence, that's the end justifying the means, right? So she sees the end she doesn't want, which is a mistrial with prejudice.
Now,
so her means not to grant a mistrial.
In fairness to her, it is the defense attorneys who have openly said, we are not interested in a mistrial without prejudice. So they have put that decision on her. Okay, is this does this reach the level of mistrial with prejudice? Then I won't allow it. If it doesn't, I'm denying the mistrial without prejudice.
I just don't think that. I don't think they should be asked. But see, it's tough. See, this is again the length of this trial has abused these defense attorneys. I mean, how is it that they're going to recover financially from this? And so if they have to redo it from the beginning and they can subject them to another year-long trial, what defense lawyer can ever afford to do that? You've won by attrition again, and that is not justice. That's not law. That's not facts. That's winning by power alone, and which we can't allow in this system. If we allow winning by power alone, we don't have justice. We don't have a democracy. We don't have a republic. We have a tyranny, because that's what tyrannies do. We can win because we're powerful, and that's it.
Now, Europe have, for instance, Europe doesn't have what you have here. Once you bring charges, you have a time limit on when you can move the case forward. In theory, apparently, because it took them 11 months to seat a jury in this trial.
This is very unusual, Nick. I don't want you to judge American criminal justice system by this trial.
No. I mean, this is the criticism Europe gets because we don't have that speedy trial right here. We have, you don't get formally charged until the first day of trial over here.
Oh, that's strange.
So you can be in custody for 2, 3, 4, 5 years before the official charges are brought, while you have, in theory, a time limit on this. But in this case,
yes,
where's the time limit? There is none. There are still 12 people after 2.5 years in jail without bond, waiting for this trial to end so theirs can start.
Well, if you're asking about speedy trial, okay. See, the speedy, I know Florida speedy trial law. So this is quite a complex subject. I don't know if you want to go into this rivulet, but I'm here to offer up my expertise if you wish. But the fact that they seated a jury within speedy trial limits gets them out of the speedy trial trap, right? So obtaining a dismissal with prejudice based on speedy trial grounds is very difficult. Now, there's two different types of speedy trial. There's statutory and constitutional. In Florida, the statutory speedy trial is very hard. You basically have to scream and shout and tell the prosecutor they're screwing up before you can actually get it. And it's very rare. We actually, when I was in the 50s, when I was working in the appeals, we had one case that we actually got dismissed for speedy trial grounds under statutory speedy trial, which was so unusual. And the state hated it so much that they changed the law.
Yeah,
it's like the state hates speedy trial. Now, what the speedy trial does is does not allow for dismissal with prejudice based on lack of thing. What it does is it gives the defense a tool to force the state to bring them to trial. Okay, that's really the effect of the speedy trial rule. There's also constitutional speedy trial, which is very outside, and that has to do with like the state really has to screw up. It's really outside. It's even more difficult than the statutory speedy trial in Florida. But we can really get in the weeds. But it's not a mechanism to get a dismissal. It's a mechanism to force a trial.
Yeah.
Okay.
Yeah. But in Judge McAfee, he is the one who is the judge on the Trump case. Now, he has made a determination that speedy trial is not when you start the jury selection. For instance, if this were to be a mistrial and Mr. Williams was the only one who still had a speedy trial right in effect, and according to Judge McAfee's interpretation of Georgia law and statute, they would have 2 months to get the jury seated, which would effectively take.
That may be in Georgia. That's not the way it is in state.
Yeah.
But it may be in Georgia that's the case.
Generally,
prejudice occurs. When does prejudice? What I mean by prejudice is, when have you done a trial? Like if a trial, when does the trial actually begin? Technically, this is a very interesting kind of legal question, and the answer is when the jury is sworn. When the jury is sworn. So you need to swear the jury in. Once the jury is sworn, then the person, the defendant, is placed in jeopardy. And if the state then dismisses the case, like for example, they screw up something. They swear the jury in, the state screws something up. They didn't disclose their witnesses properly, and they know they screwed up and they're going to lose. So their answer is they dismiss the case and then they recharge the person.
Yeah.
All right. If the recharge is after the statute of limitations, it's with prejudice and it's done. So that's why it's important to know when is somebody placed in jeopardy in front of a jury. In Florida, at least, and I think most jurisdictions, it is when the jury is sworn.
Yeah.
Okay. Yeah. Lots of little tidbits. It's useless now that I'm in civil.
Yeah, you are getting a law lesson for free by Mr. Gosney. Congratulations, viewers.
Yeah, well, and I wanted to come on because I know that you've got a lot of questions about procedural law and substance. So that's what I want to answer. I've got a few more minutes here, 20 more minutes or so.
Now, in my opinion, once they booted out Judge Glanville and replaced with Judge Whitaker, that was the big chance in this trial for Judge Whitaker to say, there's no reasonable, I cannot get caught up in time. I cannot read all of the opinions from all the decisions from a year and a half of pre-trial and trial. This is very prejudicial towards the defense. On top of this, you have this ex parte meeting.
That is the problem. Yeah. The problem with that I see that is absolutely over the hill reversible. Number one is there was an undisclosed meeting between the judge and the prosecutor and a testifying witness. Okay, now if the guy had been recused immediately, it'd be no problem. But that witness then went on to testify in front of this jury. So that jury is now tainted by that is absolutely 100% over the line. That should have been mistrial right there. The fact that if it had happened and the guy had been recused, the judge had been recused at that point, maybe there's an argument that it's harmless. But in this case, the judge and the prosecutor met with it, and the witness then testified in front of the jury after that meeting, undisclosed. That to me is a mistrial right there. That should be with trial. And I don't know with prejudice, without prejudice. To me, that's prosecutorial misconduct, and it should be with prejudice. But that's that one thing. That was the opportunity there, I think. But there's so many problems. Whatever I bounce in on this thing, and it seems like every day there's a new problem with this trial.
Yeah, and since last time, you have another person who has, the prosecution had this witness read from, the prosecution and the defense agreed on this should be redacted because it would be too prejudicial. Okay, we redact that from everything. Then this witness takes the stand and is asked to read from an Instagram photo and the handles under it and the hashtags under it. And the prosecution gave him an unredacted copy. And he started reading from it. Now, the prosecution had the redacted on the screen in front of him, but they handed him the papers. And of course, he read from the papers and read out that hashtag that was too prejudicial. And that is what caused all of this.
It could be, that could be what you call harmless error.
Yeah.
Which is appellate words for, well, it was, yes, it's prejudicial, but it's not so much that it overwhelmed the entire trial. But, this is just weasel words for the judges to get out of making a hard decision of letting somebody get a mistrial with prejudice, right? We're bending over. But see, here's the problem. The whole attitude, they're bending over so far to help the state, to prevent the state from screwing up. But they've bent so far that justice is completely been warped beyond recognition. And it's this trial is an abuse of everybody around it, and the prosecutors should be disbarred. I'm telling you, that's how bad I feel this is. They should be kicked out. They should be removed. The Georgia Supreme Court is the one that should do it. But what do I know? I'm just a Florida lawyer.
Now, I have to ask this question: is there some? The totality of circumstances is a favorite word with appellate courts and Supreme Courts. The totality of the circumstances, yes, we know all these misconducts, but in the totality of circumstances, is there a totality of circumstances regarding, for instance, we have 50 motions of mistrial.
Well, and they're legitimate.
Is there a nested misconduct statute anywhere in the United States?
There is something called cumulative error. Okay. Yeah. And that would, if I was doing the appeal in this case, for example, I would argue every little error that it is, but then I would, at the end, I'd make a last point. Even if you find this error to be not without, is not, this is an error, but it's harmless. And this is an error, but it's harmless in the totality of the term. This is error. But then I'd argue at the end, but cumulatively, all of these errors together are not harmless. Even if individually they may be, cumulatively, and that's called that's a totality of the circumstances. What you're saying, that is a cumulative error, and so yes, that point would exist in an appellate brief. And like somebody said, who was it over here? And what you mean, like the rich and famous guy Baldwin, the prosecutor makes one mistake and he gets away with it. Right. Yeah. And here, this is just mistake after mistake after mistake. It's not a mistake. It's intentional bad lawyering. And maybe they're incompetent. Maybe they're incapable of putting on a fair trial. But that doesn't matter to the defense. So, okay, well, it's okay because the prosecutors are incompetent. Well, really?
Yeah. Yeah. In my opinion, one of the arguments from the judge here was that you should have seen Prosecutor Hilton's face when he said this. There was clearly no intent. But my argument against that is, not prepping your witnesses time and time again. It doesn't matter if it is incompetence or not. It is still intent.
Well, and it's interesting because there's this standard in Florida, which is an article that I have yet to write. It's one of those that I'd like to write, but now that I'm not in criminal law, I might not be opining on a criminal subject so much, because a lot of my articles get written because something bothers me. And one of the things that bothered me when I was doing criminal law was they call it the Richardson violation. Okay, so in Florida, there's a case called Richardson, in which if you fail to disclose something and then present it in front of the jury, right? And then it's like, then the defense objects. They say, Your Honor, we haven't seen this evidence before. We want a Richardson hearing. And a Richardson hearing, it's a 3-part test. Let's see if I can remember the Richardson test. But it's like, one of them was there a violation? Was it harmful or not? Was it harmful or not harmful, right? Is it prejudicial? And then the third, was it intentional? I always had a problem with that third element. Because to me, if it wasn't disclosed and it's harmful to the defense, I don't care what the intent of the prosecutor is. That doesn't have what's that have to do with the justice to the defendant? So I always thought that third element was problematic, and I was going to write something on that, but like I said.
Yeah. And in this case, one of the Brady violations here according to Judge Whitaker, is, well, you have it now, so that curates the Brady.
Yeah, well, and judges love to do that. Like what they'll do is they'll say, well, this expert wasn't disclosed in Richardson, and it was unintentional, but it was harmful. So what I'm going to do, the relief that I'm going to grant to the defense is I'm going to let you go outside and interview that guy for an hour, and then come back in and put him on. That's like the solution for the judge, which is, I mean, these judges do not understand how much we defense attorneys prepare for these trials. I mean, you've met I don't know if you've met my Betty Rose Marie, but we've done, when doing death penalty cases, we've done trial, just jury selection, faux jury selection, basically a practice jury selection, 2 months every week. On a Friday morning, we would do fake jury selection for every Friday morning for 2 months on the lead up to trial, just on that one little issue. We would prepare so much and so hard for every little contingency, and for the judge to then come up and say, oh, there's this major piece of evidence that impacts your case, and just go out and talk to him for an hour and that'll fix it. That doesn't fix it.
Yeah. And in this trial, again, Bruce Harvey, one of the attorneys, was away that day. That day was the day the judge decided we are now going to argue Mr. Harvey's motion. But see, he's not here. He should be here.
Hey, Loa has a question. I have an answer. Hold on a second. Let me show something.
And Mr. Steele, Attorney Steele, had to go up and argue Mr. Harvey's motion. Luckily, it was a really easy motion to argue. But still, for me, that is also insanity. The day Mr. Harvey isn't there is the day she really has to argue that motion. So another defense attorney who does not represent Mr. Harvey's client goes up and argues the motion and wins it.
Here, I wanted to answer this question from Loa.
Okay, I will bring it up.
Mainly because it gives, yes.
No.
Go ahead, Ken.
Loa, can prosecutors continually not prepping witnesses be harmful error, whether it's fact, expert, or lay witnesses?
Okay, I've got ideas and answers in law, right? My compendium of my law review articles. This is now in the 3rd edition. It's available on Amazon and from me, okay? 2nd edition is available at a discount from me, but this is now the version that you should get. I've added 2 chapters based on the work that I was doing in the prosecutor's office here. And one of those articles, one of those new chapters in the 3rd edition is called, and it's only available in this book, Ethically Preparing Witnesses for Deposition or Trial. So this is a guide for how a prosecutor should prep their witnesses for trial, including a form and ethical problems with, because what happens is prepping witnesses is very dangerous, especially from the prosecutor side, because you have the huge danger of coaching them into saying false statements. They have power and they can manipulate lies. And so this is a way. And then, of course, the defense sees that and says, well, you just prepped the witness. You coached them to say what the way. So this is an ethical view of how a prosecutor should approach prepping witnesses. How do you like that? Only available in the 3rd edition of Ideas and Answers in Law. How about that, baby? And the other one, there's two chapters. The other one is kind of an interesting thing, which this is available on SSRN, which is an academic website. Inadvertent disclosures of privileged information. So when the defense or the state comes into possession of privileged information they shouldn't have, how to deal with it. This is the kind of stuff that I was working on in the prosecutor's office, but there's a lot of corrupt prosecutors that don't want to have to deal with that. They want to be able to take that information and cheat with it. They want to be able to coach their witnesses and get what they want because then they can win, right?
Judge Whitaker sanctioned the prosecution's office early on by having them retake the Brady course, the video introduction course to Brady.
What you mean? There's a lot of questions. I've only got a few more minutes here.
Yeah, but I need to say, if you want to get a Christmas present for the prosecution's office, this is the Fulton County District Attorney's Office address. So if you go buy Mr. Gosney's book on Amazon, you can send it there.
That's funny. That's funny.
So it's 136 Pryor Street, Southwest 3rd Atlanta, Georgia 30303, United States. Or you can search for the address itself. And yeah, if you want to give them a Christmas present, there are, I believe, some 70 assistant district attorneys in Fulton County.
Funny. Yeah, it's funny. You're funny. Oh, and I'm going to have a live stream tonight at 8:00.
Oh, okay.
Yes, and it's going to be on Miami traffic.
Miami traffic.
I'm sort of a reactionary, right? I like what am I dealing with lately, and so that's my latest topic. But I see that What You Mean has another question. Is it true that people who took plea deals can't go back and do an appeal? Can Steele do a cumulative error for the whole trial, even though Thug took a deal? The answer to that is,
yeah, both yes, and they can do an habeas corpus, but that they have a time limit of 4 years to do so in Georgia, and they can do a direct appeal within 30 days.
Except, but by pleading, a plea waives many of these errors.
Yeah.
Sadly, I mean, a plea deal, basically you're waived now unless you specifically reserve the right to appeal X, and that's accepted by the court or the prosecutor in Florida. Is that you basically waive everything. Now that you cannot waive things that are fundamental, like what if he pleads and he gets, it's a 5-year felony and he gets 6 years. Okay, that's a jurisdictional question. Or if he can't, if he says I wasn't told about X, Y, and Z. So there's a lot of like ineffective assistance of counsel. But I don't know, those are very uphill arguments.
Yeah.
Generally, all the stuff that's error in this trial is waived based on his plea.
Yeah. What can be if down the line somebody gets convicted because the 28 defendants, everything is technically the same trial. Even those 12 who are still waiting trial, it's still the same RICO trial. But if they're along the way, the Georgia Supreme Court says, no, these are cumulative errors, and effectively say that the Glanville thing is where they cut the line. Then the habeas corpus could argue towards...
Well,
but it's a stretch.
Maybe.
It's a stretch.
Maybe. The thing is that the problem is everything is waived by a plea deal, basically. So what he'd have to argue, they really need to reserve their error. So the way that he should plead is, okay, I'm going to plea, accept this deal, but I am not waiving the right to appeal, say the judge's coaching the witness on the stand and presenting that to the jury. I mean, be very specific. That's a winner as far as an appellate winner as far. And you either need to get the judge to agree to that or the prosecutor to agree with that.
And they didn't in this. They waived that they waived that in the appeal. Yeah.
So it's waived.
Yeah. So they are extremely limited. Now, I'm happy for Mr. Williams that he is home on probation. I really am.
Oh, is that what he got? Is that the deal he got? Yeah. Well, who wouldn't take that deal, right?
Yeah. He got 5 years, but commuted to time served, and 15 years probation. 7.5 years of those reporting. If he stays clean, he does not have to report the last 7.5 years. And if he managed to stay out of trouble, the full 15 years, they are the last 10 years of prison will be waived by the state.
Hey, Celestial Force is back. Hey, I saw her last night. I was on the expert stream. So tonight, 8:00, I'll be streaming, and it's going to be on Miami traffic. Is really the topic. I'll also say, can I tell you a secret? Is also I'm going to have a new children's book out for Thanksgiving, Christmas. It's going to be called My Difficult Dog. So I have been working behind the scenes. I haven't had enough energy really to stream, but I have been working a little bit. I've been updating all my books, making sure that the copies that are up are clean and well grammatically. I went through every book. You ever seen this Grammarly software? Grammarly, it's really good AI editing software. And I went through every book except for I've got two more that I need to work on. But I basically went through every book and revised it so that it's better, more readable. And so the books that are available. And the thing is, I really, like you're saying, somebody was saying here that you should send the books and they should have reading sessions. The problem is these people are arrogant in their stupidity.
Yeah.
Like I said, I want people to buy the books, but I really want people to read the books. Read the books, because there's content in here, but they don't. It's like I remember objecting in this one trial I had, and there was this prosecutor. It's like, I went to law school, I passed the bar, I know everything now. That arrogance is the root of their sin. And it's like, I don't need to be lectured by you, Mr. Gosney, about the law. I'm this great. I'm like, well, I said, maybe you do, because you're messing it up, right? It's great that I've got the book, but I sure as hell would like people to read it and learn it and apply it. That's why I'm writing it. I'm not writing this stuff for money. It came out in a book form because I had written so much. So I'm like, this is important stuff and I want you to read it. I think it's valuable stuff. And that's with all my writing. I want people to read it. What happened to reading? It's like everybody's got this little phone thing and they think they know the world. Read the stuff. It's important. And there's, when I write stuff, it's because there's something to be said. I don't know. Yes. And they're all available on Amazon internationally or my website, either one.
Now, I do want to show you one thing here. It is the funniest thing, saddest thing as well. This is an actual motion from the lead prosecutor. And it says, let me get it up here, make it big. Motion in limine to allow the state to present all relevant evidence to the jury and to deny defendant objections to the presentation of relevant evidence on the basis that said evidence is a waste of time, a 403.
Okay.
And this is the entirety of that motion.
What? Oh, that's crap. That's a crap motion. That's nothing. That's a nothing. Yeah. Why would you even file that? That's an Oratennis motion, isn't it? I mean, why even write? This is nothing. This is not the way you write a motion. The way you write a motion is you cite a rule, you present what the argument is, you present case law or statutory evidentiary law to support it, and then you integrate that case law and statutory law into the fact pattern that you're trying to point. What is this? This is just a nothing. This is an oral Oratennis. So this is like objection, Your Honor, cumulative evidence. It's a waste of time. And then they say, the judge looks at it and says, overruled, sustained. That's all this is. This is a nothing. How, who is writing this? Adriana Love, that's the stupid prosecutor, right?
Yeah, that's the main prosecutor in this case. And what led up to this was because the day leading up to her writing this motion, it was excruciatingly obvious that she was just trying to buy time with a witness for some odd reason. That day, the defense had 43 403s, 43 of them, waste of time, which was sustained by the judge. And Miss Love took this,
and the thing
she
is,
was so offended. She was so offended by this.
Here's what she probably did. This is stupid. This is stupid motion practice. But here's the other thing about it. The other thing is that there's a difference between the state motions and the defense motions. All right. Very different. There's a very different perspective, and people need to understand this. It's not clear. This is a little not, maybe my last point that y'all can learn from is that a defense motion is there to preserve the case for appellate purposes. All right. So you might have something you're losing. So you put that thing in writing so that the appellate court can see it and see what was being overruled in the case you're arguing specifically, right? It's a preservation issue because if the guy gets convicted, now it's before the court. The state is in a little different position because if the state comes, they lose on some evidentiary ruling and they lose, that's a not guilty. It's over. There is no preservation. The judge they can't appeal that, get the trial with the not guilty overturned, and then get a new trial. No, when it's a not guilty, it's over for the state. There is no appellate appeal from a not guilty by the state. So this kind of motion is pointless. This is basically an oral objection, but this is a lack of disciplined, stupid prosecutor. Somebody said Dunning-Kruger, who thinks that she's really smart because she's got arrogance. And she thinks she knows what she's doing because she's bickering. She's bickering. And she's like, oh, my bicker didn't work, so I'm going to bicker in writing. That is not lawyering. It's weakness. It's stupidity. It's terrible prosecution. And they all should be disbarred. How do you like them?
Oh, I love having you on. I love having you on. I mean, oh.
But that's just my humble opinion, right?
Yeah. And I heard the argument, well, maybe she turned this way after a number of years as a prosecutor. I found a case from 2012 where she argued in closing arguments in front of the jury that the defendant's silence was shown of guilt.
Right.
That he didn't talk to the cops, that he didn't testify. Now that was appealed. It was granted by the Georgia Appeals Court. It was sent down for a new trial, and that trial just said you don't have a case and threw it all out. But that guy still served 5 years in prison.
Right. Yeah, that's right. That's the
for something that wasn't even a crime.
There's a big United States. I think it has been clear because that there's a big problem in this country about prosecutorial, unchecked prosecutorial power. And there is no check on these people, and the absolute power. Lord Acton, absolute power corrupts absolutely, and these are positions of power that basically has absolute power. There's very little check on them, and Soros has got a smell of that. That's why he's targeting these races. Is people don't even see the prosecutor's office as being. It's like, oh, that's just some ministerial thing, and yet. Then he gets these people, these hard leftists in these positions of power that turn this absolute power position into a weapon against political enemies. And it's a weakness in our country that, maybe wasn't foreseen by our founding fathers because, and so, I mean, this is a weakness and we need to really check that, especially equal protection of the law.
Yeah. I mean, your Constitution is unique in this world. The Bill of Rights, they are unique. Few Western countries has what you have. For instance, you have double jeopardy. We don't.
Yeah.
We get over here in Sweden, if the prosecution thinks that, oh, he only got 10 years in prison, we want more, they can appeal that in order to get a harsher sentence. If a person gets acquitted here in Sweden, the prosecution can appeal that to higher court to get a conviction. If they do a lousy job in the lower courts, they learn from it, they appeal and present a better case.
Right. Well, actually, who was it? And I'm trying to think about, I think it's George Mason. I might be wrong about that. But, in our constitutional history, there was a big debate about the Bill of Rights, okay, and whether or not the rights need to be enumerated. So what you're talking about, back when our country was first founded, the Constitution was put forward. And one of the biggest criticisms of it, I believe it was George Mason, was that it did not have a specifically enumerated Bill of Rights. And the Constitution was going to fail over that issue. But there was a compromise that was done where in certain states adopted with the idea that a enumerated Bill of Rights would follow up immediately by amendment. And that's how we got the Bill of Rights. And there's still kind of debate about that because in fact, my book Prepare leads with this very question about the enumerated rights being a limiting factor or an expanding factor. It's about the problems with a Bill of Rights. And we're still sort of struggling with that issue. But what you're talking about is that you're basically arguing the George Mason position that a Bill of Rights is very important because if you don't have that, the government just encroaches on everything and says, well, yes, you've got that right, but not in this instance. And they say that in every case, right? So you don't have anything. So it shows you the wisdom of the founding fathers and James Madison's idea.
Yeah, and I had a really good point, but I forgot it.
I got to go. We've got some things to do today. 8:00 tonight, I'll be streaming, and just for fun. And I'm just trying to, I have a little energy. I got a little topic I want to talk about, and I'm still feeling my way back into the world of streaming. But I did want to come on and say thank you, Nick, to you personally for supporting me in your own way. We have different perspectives and different ways of going about it, but it takes a team. I mean, I'm good at some things, you're good at some things, and we should bring out the best in each other, and we should work together. And that's something that you have done for me, and I'm humbled and blessed that you're in my life, and thank you.
I remember one of these trolls on Twitter said, Mr. Gosney doesn't have real friends, he only has these internet buddies. Folks, Mr. Gosney is my friend.
Thank you.
To you guys who tried to more or less end Mr. Gosney, I still know who you are. I know it. I still know. And I have... but...
I know. Well,
Mr. Gosney is moving on, and I don't want to screw that up. And I believe for now, it is worth more for me to see Mr. Gosney having a good life moving forward than to ruin yours. But I will do it if necessary.
Well, this is the thing. There's always the need for a door kicker, and as much as I'm about peace and love and Christianity, there's also the people that are out there who are willing to go to war. And, and the thing is that that's not a positive way forward, but it's a necessary thing. Like, it sucks that we have to have tanks and military planes and stuff. But if you don't, evil wins. They take over by force. They take over by power. So, don't engage. I'm just saying, as people, as humans, as an appeal to the left or the liberals, the good-hearted liberals, engage in honest and true and respectful dialogue with your opponents. Don't go into this personal destruction world, because it destroys everybody. It will destroy the humanity ultimately by its viciousness and vileness. And but there's a need for good to have armor and a sword. The armor of God exists because, and one of those weapons is a sword, because good needs to defend itself. And we all have our roles within that. As long as are you on the right side? Question.
Yeah, and if you go by the Christian way, I mean, even Jesus, when necessary, was not a stranger. I mean, what he did against the battlers in the temple, that wasn't especially peaceful, but it was necessary at that point in time.
Right.
I don't claim to be anywhere near Jesus. But,
and then in the Garden of Gethsemane, if you remember, when Judas betrayed Jesus, and the Roman guards, he kissed Jesus, and the Roman guards came to seize Jesus, right? They had swords. The disciples had swords, and one of the disciples took out a sword and chopped the ear off of a Roman soldier, right? But Jesus said, no, because you're preventing the fulfillment of the prophecy of the Messiah. So you are, by fighting, we're not here to fight the Romans, because my destiny is to be crucified and rise on the third day, right? But the disciples didn't know that, but they were armed. So yeah, it's, Christianity is generally peaceful and turn the other's cheek, but there's this warping of Christianity that has been done by the secularists, who have said, oh, well, this is what you stand for, so you can't fight back. No, but you have to be judicious. You have to be very humble and careful about it. But there is a need to defend good and to protect the innocent. You can't protect the innocent if you're powerless.
Okay.
Hey, man. God bless you. I'll be around. We'll see you around.
Okay, thank you for showing up. Thank you so much. I posted Mr. Gosney's Mr. Gosney's channel, and his books and everything are posted in the chat. I will post it in the description to this stream as well.
Bye-bye.
Thank you, Steve.